next question is actually, this person who asked this question is a legend. So you'll soon realize why. So it says, I have an eviction order for my non-paying tenant. The tenant is slowly moving out. The tenant, however, has taken my municipal bin and is leaving about 2 tons of rubbish behind after 2.5 years of occupancy. I use my PI skills and find out where the tenant is moving to. Would it be legal? Sorry, would it be legal for me to assist her in moving the rubbish to her new residence? I feel it's highly unfair that I have to clean up behind the tenant, which is true. Also, can I lay criminal charges for the theft of my municipal bin? Cilna.
Okay, so to start with, well done to the viewer for actually getting an eviction order and not just doing illegal things. So well done on that one. The moving out thing that's happening slowly is good. I mean, that's already, we're happy about that, happy about them moving. And even if it's taking a bit longer, at least you don't have to pay the sheriff to do it. Because in fairness, if you had to instruct the sheriff to do the eviction, the physical eviction, what's going to happen is the sheriff goes in with contractors. They basically chuck everything out on the sidewalk, but they leave more rubbish behind. And I've been present with a few evictions, and it doesn't look like. My sister recently immigrated, and she had like this moving company. They came in, they packed everything, every single thing, like even the last little bit of toilet paper on the toilet roll gets rolled up, and it's amazing. That's not the sheriff. The sheriff doesn't evict like that. The sheriff doesn't pack boxes and move everything politely. They basically chuck stuff out, like on blankets. They carry it out on blankets. And if there's stuff that gets left behind, it gets left behind. And there's usually a lot of things that gets left behind by the time the sheriff changes the locks, all the rubbish, everything. So to answer the legal side of the question, it wouldn't be illegal to take this stuff and dump it at the tenant's property. However, it depends on the intention. And I am worried that there might be an intention to cause damage to property where they are staying. And then I am concerned about the criminal aspect of malicious damage to property. It depends on what it is and where you're going to dump it. But if you dump it in a way where it's going to cause damage to the property, there could be a criminal element to that. Other than that, it's not illegal. Also, my concern is less a legal concern. My concern is more, and my advice is more in a more pragmatic sort of practical approach here. I am afraid that this would be more cutting off your nose to spite your face, because to pick this stuff up and to remove it is going to have, there's going to be a cost involved. And the statistical chance of that tenant picking it up and dumping it back is there. And then we end up with, throwing the paper this side and they throw it back and back. I don't think it's practical. I can't see that it's going to be illegal unless, like I said, it could be seen as malicious damage to property, which is unlikely, but I wouldn't recommend it just because I can see more detrimental repercussions. That's not necessarily illegal or criminal repercussions, but yes, a legal term you don't hear every day, pain in the butt repercussions, because it could cause massive back and forth, and it's more harmful than what you would actually get the satisfaction from. On the stealing of the municipal bin, it was stolen with if you can prove that the elements of theft is obviously intention, and then you had to actually take this thing with the intention to now have it as yours, and you knew that you aren't allowed to have that. So in this case, I think it does tick the boxes of theft. Practically, to go to the police and lay a charge of theft, and you have to do all the affidavits and everything on a municipal bin, depending on how badly you want it and how cool you are with hanging out at the police station. There's definitely merits in that, to be honest. Merits in actually getting prosecuted. Achman, what's the legal term? The part where they say that it's such a small issue, they minimis non curiat lex. That's what I'm looking for. It's too small. It's such a small thing to, and I'm sorry, but that's a Latin translation, waste the court's time with. So I'm not saying it's a waste of court time. I would rather add the cost of replacement of the bin to the already damages that you've suffered, and approach the rental housing tribunal to collect your arrear rental as well as the bin cost from the tenant that you are evicting. So I hope that's practical advice in this circumstances.
It really, really is. So thank you, Cilna. And also 2 tons of rubbish being dumped somewhere on some poor, unsuspecting landlord's property. I think, it's really concerning. Cilna, on that note, here's a question for you. It says, we moved into a house in the beginning of September. It's a rental agreement. The house looked perfect when we moved in. A day after taking occupation, we noticed a bubble in one of the walls and water leaking from it. We immediately reported this to the estate agent. The estate agent nor landlord has taken any action with regard to this damage that we're seeing now developing. My family, around the same time that we noticed this, is also experiencing chest issues, bronchitis, coughing, and the viewer says that it's in part because of the mold that is now forming on the walls of this property. The viewer wants to know, what can they do to force the landlord into repairing this sooner rather than later for the sake of their family's health? And would it be grounds to cancel the lease agreement? I mean, nobody wants to live in a place that is hazardous to their own health and the health of their family members. Cilna, what advice can we give this viewer?
It's a brilliant question, and I'm so glad we got this question, because we usually get him from the other side. Early cancellation. I'm sorry, guys, you're just going to have to ignore this. It's not going to help. But so we usually get the question from the other side. Tenant does an early cancellation in terms of Section 14 of the Consumer Protection Act. Now they have to pay an early cancellation penalty. And how does that work? Why is that a thing? So I think what's important about this case is about this question. If there's a reason why the tenant wants to cancel the agreement, like mold in the property, or the front door fell off and the landlord doesn't want to repair it, stuff like that, not I don't feel the water pressure is good enough, like actual things where you can see this is a problem and the landlord doesn't want to repair it. A tenant needs to remember always, as much as the landlord has the right to place the tenant on terms, allow him time to remedy his breach, and if he doesn't remedy his breach, the landlord can cancel the lease agreement and claim damages from the tenant because of this early cancellation of the agreement. A tenant has exactly the same right. And this right that a tenant has cannot be contracted away. A landlord can't say that a tenant can't place him on terms. Even if the lease agreement says that, that's contra boni mores and it's unenforceable. So I think it's the first most important thing to realize is go have a look at the lease agreement, find that clause in the TPN leaseback lease, it's clause 24, and you need to give the landlord written notice to remedy his breach, give him the allowed time to do that. And if he doesn't, you cancel the agreement, but then you don't cancel in terms of section 14 of the CPA. So then the landlord doesn't have an early cancellation penalty claim against you as the tenant. You have to place the landlord on terms, clearly say, what is the problem? What are you doing that I feel that you are in breach, that cause you to be in breach of the agreement? What do I need you to do to repair that? And what is the time period, this will be in terms of the lease agreement, to repair the breach? And if they don't, you can cancel. Be careful of claiming things like health issues for the family, because you need to be able to prove a nexus, so a clear line between what's happening and the damage it's causing. So when it comes to mold, I do appreciate that it happens quite often that black mold, I mean, we all know black mold causes lung problems, but rising damp that causing bubbling in plaster and stuff, most of the times it's pretty harmless to health. So why I'm saying this is I'm not a doctor and neither am I a plaster expert, but it's important to be aware of this, because the moment you start bringing facts to the equation that might not be actual facts, it might be anecdotal facts, but that's not sufficient to be a fact. So be careful of doing that and muddying the water. Keep to this simple fact. There's rising damp, it's causing, it's not pretty, it's interfering with my undisturbed use and enjoyment of the premises. You have 20 business days to repair this. If you don't, I'm going to cancel and claim damages from the landlord, because now the tenant, because he followed the right process, does have a damages claim against the landlord and not the other way around. So it's something very important to keep in mind. I think tenants very often err more towards, I want to cancel because I have a reason to cancel, instead of following due process as simple as a landlord would. Letter of demand, you haven't paid rent, you have 20 business days to pay your rent and remedy your breach in full. If you don't, I'm going to cancel and evict you. Same thing for a tenant. Place on terms, and if he doesn't repair the damage, you can cancel and claim damage from the landlord.